Here's the DUI marijuana trap that's convicting completely sober drivers. For example, let's say you smoked a little weed earlier in the week, but today you're completely sober. But you're driving down the road, you get pulled over for speeding, there's some old burnt smell in your car, and guess what? And the officer ends up arresting you after some field sobriety tests, and you're being charged with marijuana DUI. And then the blood test comes back positive for Delta-9 THC. Now what? Now you're facing a DUI marijuana charge, and you're having to go to court and fight it. And here's some problems with the science that could be convicting completely innocent people. The Delta-9 THC doesn't completely leave your body immediately. It can be tested positive for days and up to a week plus. And here's the problem. The detection window and the impairment window are two separate time frames, and that's your defense. And here's the reason why these cases are beatable. There's no correlation between the Delta-9 number and proof that you're impaired. That's unlike alcohol. Secondly, when defending this type of case, we're using your smoking timeline versus the timeline of driving to show that there's no correlation and no proof of impairment. And again, don't do the field sobriety test. And thirdly, by using an expert, we can show that there's no correlation between the Delta-9 number and driving impairment. The prosecution's problem is that they have to show that you were impaired by marijuana at the time of driving, not that you had marijuana in your system. That's a big hurdle. As a member of the California DUI Lawyers Associations, I've beaten these marijuana cases. If you've been charged in Southern California with a DUI marijuana, give me a buzz. No pun intended. 951-540-0844.